Welcome to the Employment Discrimination Section's main program for the annual meeting. Before we get started, I have one quick housekeeping note. If you're interested in getting involved in the Employment Discrimination Section, especially as a member of the Executive Committee, which as the current chair of the section, I highly recommend, please join us for our section's business meeting at the conclusion of this session. I will put the separate Zoom link for that meeting in the chat for those of you who would like to join. But if you're unable to participate in that meeting, but are interested in joining the Executive Committee, please feel free to email me directly. My information is in the speaker bio section, and I will follow up with you. So now back to our program. This panel draws on the annual meeting's theme, the power of words, by considering how Trump's divisive and derogatory rhetoric has affected and will continue to affect anti-discrimination enforcement in the workplace. The last few days have certainly been a reminder of how far-reaching and potentially long-lasting the impact of Trump's presidency will be on our country. And we have a fabulous panel of scholars and speakers who are going to each address a different aspect of this issue. I have the privilege of being your moderator this morning, and I will briefly introduce the speakers in the order of their remarks. Our first speaker is going to be Professor Ruth Kolker. She is the Distinguished University Professor and Heck Faust Memorial Chair in Constitutional Law at The Ohio State University Moritz College of Law. Professor Kolker will be talking about the impact of insults generally on anti-discrimination enforcement. She will be followed by Professor Michael Green, who is currently the Professor of Law and Director of the Workplace Law Program at Texas A&M University School of Law, and the incoming Professor of Law and Director of the Institute for Law in the Workplace at the Chicago-Kent College of Law at ITT. Professor Green will be talking about the impact of Trump's rhetoric on racial minorities in the workplace. Professor Sahar Aziz joins us from the Rutgers Law School, where she is Professor of Law, Chancellor Social Justice Impact Scholar, and the founding director of the Center for Security, Race, and Rights. She will be discussing the impact of Trump's rhetoric on Muslims in the workplace. Professor Katie Iyer, also at the Rutgers Law School, will be talking about her scholarship on the impact of Trump's rhetoric on LGBTQ rights. And finally, last but certainly not least, we welcome William Creeley, who is currently the legal director of FIRE, the Foundation for Individual Rights in Education, and he will be discussing the impact of government free speech doctrine on faculty, a topic that I know is near and dear to many of us. We've decided that each speaker will discuss their individual topic for about 5 to 7 minutes, and then we will turn to an open Q&A with the audience. We really want this to be an interactive session, so please feel free to put your questions in the chat throughout the presentations, and I will direct those questions to the panelists when we get to our Q&A session. I will now turn it over to our first speaker, Professor Kolker.
Well, thank you so much. Thank you all of the audience for participating, and thank you, Stacy, for helping to arrange what I know is going to be a fantastic session. I think it's a little timely. And so let me sort of try to provide my own insights into the topic. I want to just talk briefly about a book I have coming out in October 2021 by California University Press. And the title of the book is The Public Insult Playbook: How Power Bullies Undermine Civil Rights Reform. And I probably could just stop with the title and you would have some sense of what I might have to say, but I think I should go a little bit further. And so what I talk about in the book, which is so relevant to our topic today, is that when we think about public insults, and I don't think I need to share with you that that's become a commonplace of our political rhetoric these days, I think about them not in the immediate sense of how do these insults impact a particular individual, you know, when someone has a racial epithet uttered at them, how does it affect them as an individual? Of course it does profoundly, and I don't mean to say that it doesn't. But in the book, what I try to talk about is how the use of those kinds of public insults, which of course Trump has made commonplace in our everyday discourse, have a structural effect, that they undermine civil rights reform. And I think that we need to know that, account for that, anticipate that, if we are going to be more effective in the use and deployment of civil rights. And so in the book, I talk about 3 different ways in which I think public insults undermine civil rights reform. The first way is by deflecting attention away from the need for structural reform. The second example is when it serves as a headwind to effective reforms that we might want in the future. And the last method I mentioned is what I call a deadweight effect, that even when we think we've implemented effective reforms, the public insults act as a deadweight on those reforms. In the book, I have a lot of different examples. I have examples from the disability field, immigration, marriage equality, abortion, and sexual harassment. And I also talk a lot about the effectiveness of the Black Lives Matter movement and how it in many ways has understood the message that is central to my book. But let me sort of right now in the few minutes I have, just share an example of a deflecting example, a headwind example, and a deadweight example, so that we can be thinking about what we can be doing in the future to use civil rights laws in a more effective way. A deflecting example is one that is unfortunately familiar to too many of us. I'm sure we all remember, unfortunately, when Michael Brown was murdered on August 9th, 2014 by Officer Wilson. What you may also remember from that time was that as soon as that murder took place, the press, the political right started talking about whether Michael Brown had a criminal record, which was completely irrelevant to whether the shooting was justified. And that very much took over the public discourse and therefore stopped people from talking as much as they needed to about the need for broad-scale structural reform in the United States with respect to how we deal with police violence. By contrast, this is a good story, although it's not a really good story. I'm sure we all remember on May 25th, 2020, when George Floyd was also murdered. But that time, I think a lot of people in the political left, a lot of people in the Black Lives Matter movement were ready. They knew what was going to happen. You saw people post on public media, if it was me who was killed, they go back to my third grade report card and say how I spit at someone, right? And so people were ready with a response on the streets, a collaborative response. And so even when President Trump called the protesters thugs, which is of course a word that we all were using yesterday against some other people, but when President Trump used the word thugs to describe the protesters, it didn't have that same effect. We were ready for it, we anticipated it, and the conversation moved instead to more systematically, how can we counter police brutality? And I don't mean to say we've solved the problem of police brutality, obviously we haven't, but the conversation at least is moving in a direction of asking what we can do to eliminate police brutality, because we're not allowing the public insult playbook to take over and deflect attention from what is really important. As a headwinds and deadweight example, really, let me just give one more example because I don't have a lot of time. This is an example that's dear to my heart as a disability rights advocate. I'm sure many of you remember in November 2015, when Donald Trump, the candidate, mocked Serge Kovaleski by flapping his arms, right, and pretending to imitate Kovaleski's congenital joint condition. And that then caused everyone to say, oh, is this the end of the Trump, campaign because he mocked people with disabilities? And obviously it wasn't. Unfortunately, it should have been, but it wasn't. But my point is, does anyone remember why Trump mocked Kovaleski? And when I give this talk, when I have more time, I'm always surprised at how few people in the audience can remember why Trump mocked Kovaleski. And the reason he mocked Kovaleski is Kovaleski had written an article in the Washington Post that Trump had tried to misappropriate to say that Arab Americans were cheering 9/11 from the rooftops of New Jersey, when in fact, of course, they weren't. And so the conversation in the media had been whether Trump had lied about Arab Americans and what they had done after 9/11. And Trump is able to stop that conversation and move it to Kovaleski, whether he's been insulted, instead of having us talk structurally about the need for immigration reform. And so that was a headwind to us being able to have the conversation we needed to have. So if we have time in the Q&A, I can give you some more examples. I've got a book full of them, but I hope that this helps us think about the power of the public insult playbook that is much more pervasive than people might ordinarily understand. Thank you.
All right, thank you, Stacy, for allowing me to be a part of this great group, great discussion, very interesting things that Ruth just talked about. In such a short time to cover Donald Trump and race, It really is a daunting task. A couple years ago, I wrote an article that was in the Harvard Negotiation Journal about negotiating race in the workplace after the Trump effect. And it is amazing the number of incidents that have occurred since I wrote that. That was actually at the midpoint of his first 4 years. So we had 2 more years to go. And it is shocking the number of incidents that have occurred where he has made comments or refused to address things and supported groups, white supremacist groups and other conservative groups regarding race. So unfortunately, as I started to do this, I thought this is a daunting task. What could I start with? And then we had yesterday. And with yesterday's events, I actually decided that knowing that the theme of this conference is the power of words, knowing that we as a panel are really supposed to be looking at the impact of the president's words in the workplace. And I actually want to start with something that Joe Biden said yesterday, President-elect Joe Biden. The words of a president matter. At their best, they can inspire, but at their worst, they can incite. And if we take that comment and look at a number of the comments that the president has made and continues to make, and I think it's interesting that Ruth mentioned the statement that he made where he was actually mocking someone's disability. But he has basically reduced his commentaries to the point where it doesn't matter which group he is willing to attack. And even in the article, I had documented his attacks based on disability, sex, race. And actually, when Ruth said she thought that maybe this is the one thing that will get him in trouble, and this will be the chance where you'll see that there will be blowback. Actually, the one that was the most telling to me that he would not get blowback was when he attacked Senator McCain as a POW. You would think that veterans would be such a strong part of his political base, and he made comments ridiculing John McCain for being caught as a prisoner. And when you didn't have any response to that, I realized, and he has even said this, like he could go out and shoot someone if he wanted to, that he could make comments and there would be no consequences for those. And when we think about this in the context of race, so what does that mean? That means that you have the leader of the free world openly making negative comments, ridiculing people, making fun of people, using Twitter and other forms of social media like no other president has ever done in such a negative, humiliating, bullying way. And there's no consequences. What that has done is created an environment in our society where people who are supportive of various racial, white supremacist, conservative theories and beliefs also feel invigorated in being able to say and do and make comments without any consequences. And we saw that even yesterday. In my paper 2 years ago, I highlighted the Charlottesville incident, where President Trump said there were good people on both sides when the two sides were white supremacist organizations and protesters against white supremacists. And what was really more shocking to me in this day and time, and I think this is the impact of President Trump's statements in terms of race and in the workplace, is that we don't see people hiding anymore. We don't see them wearing masks. And it's ironic that in this time of COVID, where you could wear masks, these groups of people are specifically refusing to wear masks. They are coming into places openly and hostilely making statements based upon race and other protected classes, and feeling like there is no consequence for them. So they're willing to be as open as possible. Even yesterday, you saw individuals who lined up against the police. And I know that there's various pictures on social media where you see the police presence when it was Black Lives Matters protest in front of the Capitol. And then you see how the police were lined up for yesterday's protest. And there's a very stark difference. But even once these people violated the law, they went into the Capitol. They took pictures of themselves, no mask. They took letters out of Speaker Pelosi, took a letter out of Speaker Pelosi's office and showed it to everyone openly and said, I didn't steal, I left a quarter. And everyone knows who this person is. And you may go back to your workplaces and realize there were people that you worked with who are on those videos. And that's the impact of Trump in the workplace. I know I could say more, but my time is up. So I really want to highlight to you that there's a significant issue there. But if we realize that in a number of days, less than 2 weeks, he'll be gone, maybe it'll be better for all of us. Thank you.
Thank you, everyone. And thank you, Professor Hawkins, for moderating and organizing the panel as well as the section. It's a privilege and an honor to be here along these esteemed co-panelists. So today I'm going to focus on how Islamophobia and anti-Muslim racism has infected the workplace, which unfortunately is not a post-Trump phenomena. It has been particularly egregious for 20 years, since 9/11, and certainly existed before 9/11, but the last 20 years have been extremely difficult, to put it mildly, for Muslims in the United States, and so far as protecting their civil rights or preserving their civil rights. So I want to start by just making an overarching point, which is that in my analysis of employment discrimination law, which is aimed to protect employees from hostile work environments, among other forms of disparate treatment, is that the law is weak and it favors employers. Employee plaintiffs are rarely able to meet the alleged harassment standard of severe or pervasive, resulting in most cases being dismissed at summary judgment, regardless of the identity of the plaintiff. And as I wrote in 2009 in a law review article called Sticks and Stones, the Words That Hurt, Entrenched Stereotypes Since 9/11, Muslims have been experiencing hostile work environment claims directly arising from pervasive stereotypes that Muslims are terrorists, Islam promotes violence, and Muslims do not belong in America. And in that article, I combed through all the Title VII cases brought by Muslim employees for hostile work environment claims, and provided the evidence of how Islamophobic stereotypes infect the workplace. Now, notably at the time, the Bush administration's anti-Muslim rhetoric was steeped in national security rhetoric in the context of an indefinite global war on terror, indefinite detention of detainees, Muslim detainees in Guantanamo Bay, military occupation of Afghanistan, and an illegal invasion and occupation of Iraq. So Americans have been deluged with images of so-called Arab-looking Muslim men as terrorists, barbarians, and anti-American. And as a result, verbal harassment of Muslim employees mirrors those stereotypes, as they are in fact called in the workplace terrorists and traitors, questioned on whether they were taught how to make bombs when they attend their mosques, and told they should go home and get out of America. Now, the election of Donald Trump as president of the United States And his candidacy, the 18 months prior, starting from June 2015, further legitimated and exasperated these stereotypes. And as expected, Muslim employees suffer the harmful consequences on through threats to their job security, employment opportunities, as well as in other forums such as schools, public spaces, and immigration. Now, in the limited time I have to speak today, I'll be focusing on this direct link between Trump's rhetoric and anti-Muslim racism expressed in the workplace. But let me highlight a few of the many anti-Muslim statements made by Donald Trump. In November 2015, Trump endorsed a registry for Muslims. When he was asked by a reporter, do you think we need to register Muslims in some type of database or note their religion on their ID? Trump responded, there should be a lot of systems beyond databases. We should have a lot of systems, and today you can do it. He confirmed his approval of government officials going to mosques to, quote, sign these people up, end quote. He acknowledged that different places, you sign them up at different places, but it's all about management. Our country has no management, end quote. And so throughout the 12 months prior to the presidential elections, while he was running, Trump made clear his deep suspicion of Muslims as terrorists or terrorist supporters. For instance, he stated that, quote, it is hard to separate who is who between Muslims and terrorists. He also insisted, quote, hundreds of thousands of refugees from the Middle East, end quote, would attempt to, quote, take over, end quote, and radicalize our children. He also warned that Syrian refugees would be a better, bigger, or more horrible version than the legendary Trojan horse. If you want to read more details on that, I'd point you to my law review article, A Muslim Registry, the precursor to internment, question mark. Now, Trump's incendiary statements against Islam and Muslims culminated in the infamous and notorious Muslim ban that was issued in January 2017 and eventually diluted a bit, but blessed by the Supreme Court, which effectively excluded tens of millions of Muslims from visiting the US and coming as non-immigrants. Now I want to shift to the numbers. So as part of a larger research project on civil rights violations of Muslims in post 9/11 America, I've thus far found 272 cases of employment discrimination against employees on account of their Muslim religion, among other protected classes. And that research is ongoing, so I anticipate there will be more, particularly as the cases that may be going through the EOC, internal administrative complaint process, eventually go into the federal court system. Now, keep in mind that employment discrimination cases that result in a lawsuit are a tiny fraction of the total number of discrimination incidents because employees are often afraid to file internal administrative complaints with their HR departments or the Equal Employment Opportunity Commission. And even when they do file complaints, the number that actually proceed to litigation is very small. Now, Now, I'll highlight the facts of a couple of cases brought since 2015 that demonstrate the direct link between Trump's rhetoric or policies and the manifestations of anti-Muslim racism in the workplace. So in one case, in the District of Colorado that was filed in 2019, Qasim Andalib, a Muslim of Moroccan national origin, worked in the HR department of JBS's beef processing plant since he had been working there since October 2015, which is a year before Trump announced his presidency. In April of 2016, after Trump is elected, a new trainer was hired in the HR department. This new trainer, who was a co-worker, told the plaintiff, quote, during a discussion about the Trump's, this is a quote from the complaint, during a discussion about the Trump's administration's newly enacted ban on Muslim immigration in the United States, that it's all your fault, you freaking terrorists, end quote. Now, although the plaintiff complained to the HR director, the company did not investigate or remedy the complaint. In early 2018, the same coworker who made the anti-Muslim statement directed the termination of another Muslim employee of Somali origin. When the plaintiff inquired as to the basis of her termination, the coworker stated, quote, I was doing my share of making America great again, end quote. In another case, Hassan V. Cree in the Eastern District of Wisconsin, during a conversation at lunch in an on-site training session, an employee asked her supervisor if she intended to vote for Donald Trump, to which the supervisor answered in the affirmative. The employee stated, but Donald Trump wants to send all the Hispanics back to Mexico, end quote. And the supervisor responded, quote, good, that is where they belong, end quote. When the supervisor confirmed that she knew the employee's husband was Latino. Now, the next day, the plaintiff, Talia Hassan, was in a meeting wherein a coworker asked the same supervisor who had made the anti-Hispanic, anti-Latino statement for her feedback regarding an applicant who was Muslim for a vacant management position. The supervisor stated that she would not be comfortable working with a Muslim because she believed Muslims are violent people. Another coworker chimed in stating she too would not feel comfortable working with a Muslim because, quote, they do not belong here, end quote. Now, Hassan, the plaintiff, expressed her displeasure with the remarks and informed them that she was actually Muslim. The supervisor told her that she had no idea that she was Muslim, but restated that she would still not feel comfortable working with the Muslim applicant. Now, an interesting aspect of that particular case is how identity performance in dress, accent, name, and phenotype affects how Muslims are treated in the workplace. Hassan obviously passed as non-Muslim, maybe due to how she looked, how she dressed, how she talked, where the applicant may have been, the Muslim applicant may have been a woman who wore a headscarf, or a man whose name was Muhammad, or had some other marker of a Muslim identity. Now, if you want to learn more about how identity performance and racism and Muslims intersect, I point you to my article, Coercive Assimilationism, The Perils of Muslim Women's Identity Performance in the Workplace. Now, in both of these cases, the plaintiff was not successful in their claim, which is no surprise. And the point here is not so much to get into whether the judge made the correct ruling in dismissing on summary judgment, which is where most of the employment discrimination cases die. It's really just to highlight how there is a very real effect between what is being portrayed in the media, what politicians say, and that yes, words hurt and words have very serious consequences.
Sahar, I just want to remind you of the time counter, and if you could wrap up so that we could accommodate the other speakers.
Oh yes, I'm sorry. So I will just leave by saying that I will conclude by saying that I hope these past 4 years have made it crystal clear to liberal lawyers, to liberal judges, and to liberal law professors that the law is failing to protect minorities from the political tyranny of the majority, including in the workplace, and that we have our work cut out for us in reforming the law. Thank you.
Good morning, everybody. I'm delighted to be here. Thank you to Professor Hawkins for inviting me to be on this panel and to my co-panelists for their remarks. So in comparison to some of the other areas that we've already been talking about here today, President Trump's rhetoric about LGBTQ Americans has actually been, for him, fairly restrained. And indeed, especially during the 2016 campaign, he explicitly sought to court LGBTQ voters. But of course, that does not mean that LGBTQ individuals have avoided the harms of the Trump administration, far from it, or that his general emboldening of bias has not affected the LGBT community. So I want to start by talking just a little bit about how President Trump's general emboldening of bias has affected the LGBT community, and then I'm going to turn to talking about some of the specific measures that the Trump administration has taken that indeed have been incredibly harmful to the position of LGBTQ workers. So first, while we don't have great data on employment specifically, hate crimes data can give us a window into the impacts that some of the other panelists have already talked about this general emboldening of bias, right? So as Professor Green talked about, Donald Trump's ability to say incredibly racist, biased things, to do incredibly racist, biased things, biased across a variety of dimensions without any consequences, we've really seen that spill over to a sort of emboldening of open bias generally. And that is true in the LGBTQ domain as well. So if you look at statistics on hate crimes spanning the period from just prior to the Trump administration through the final year for which statistics are available, which is 2019, you see very significant increases in hate crimes against the LGBTQ community. For transgender people in particular, those increases have been quite staggering, on the order of approaching 100% increase in the reported hate crimes. And I think that is the direct consequence of this type of sort of permissiveness around it's okay to engage in this type of hateful, biased activity. Second, in terms of the actions of President Trump and his administration, we've really seen a fairly unceasing assault on LGBTQ rights, especially on the rights of the transgender community. This has taken place across a really wide variety of contexts. Since this is an employment panel, I really want to focus on three particular areas which are specific to employment. So first, President Trump, of course, ordered and implemented a facial policy of discrimination against transgender people in military service. This led to concrete adverse outcomes for our transgender service members currently serving in the military, as well as those who wished to serve. But it also sent a very powerful signal to the rest of the employment world as to our federal government's perception of the acceptability of anti-LGBTQ employment discrimination, right? There is no more powerful signal you can send than to endorse your own and adopt your own facial policy of discrimination. So that is one important issue here. Second, across a wide variety of domains, the Trump administration has been sort of pursuing a project of trying to ensure that religious beliefs can serve as a shield against discrimination claims. That would affect a wide variety of groups if it were permitted to apply broadly, and if the courts endorse it in the broad way that folks within the Trump administration have been pushing for. It would be specifically harmful to the employment rights of LGBTQ individuals. And that's especially so because the sort of perspective that many within the Trump administration and indeed the Supreme Court have put forward is a position of sort of extreme deference to claims of that individual discrimination is religiously compelled, a sort of hands-off, we can't interrogate the sincerity of those types of claims. Finally, in the context of employment discrimination enforcement, the Trump DOJ, of course, completely reversed position from the Obama DOJ in arguing that LGBTQ Americans are not covered by Title VII's sex discrimination protections. This matters quite a lot because, of course, we do not yet have a separate, independent, nationwide law that provides protections for sexual orientation and gender identity. So if there's going to be nationwide protections, it is, of course, through Title VII sex discrimination protections. The Trump administration not only retreated from advocating that LGBTQ folks are covered under sex discrimination law, they very actively sought to participate in arguing against that position in court, which led to the strange spectacle of the DOJ contradicting its own employment discrimination agency because the EEOC, as an independent agency, adhered to its existing position that anti-LGBTQ discrimination is indeed sex discrimination under Title VII. Of course, this part of the story ends with a happy ending, and so that's where I want to conclude my remarks as well. On January 15th, 2020, the Supreme Court, in an opinion authored by Trump appointee Neil Gorsuch, held that as a matter of Title VII's plain text, anti-LGBTQ discrimination is indeed because of sex. It would not have occurred but for the sex of the individual, the actions that an employer opposes, or the orientation that an employer imposes. It would not have opposed in somebody it perceived as being of the opposite sex. And thus it is prohibited by Title VII. So despite the best efforts of the Trump administration, LGBTQ employees going forward do have clear nationwide protections under Title VII's sex discrimination law. So I'll go ahead and conclude there and turn it over to our next panelist.
Good morning, everybody. Thank you so much. It's a pleasure and an honor to be here. Thank you, Professor Hawkins, and thank you to the staff and the attendees of the AALS conference, and of course, my fellow panelists here. I could listen to everybody for much longer than 7 minutes because, as I think a couple of folks have noted before me, this is certainly a timely topic to talk about today. A little bit scattered in my thinking, so I've selected two stories from many at my work at FIRE that may be illustrative of how the rhetoric from the top, to speak euphemistically, filters its way down to the bottom. At FIRE, just as a quick introduction, I serve as the legal director. We receive case submissions from students and faculty from campuses across the country, public and private, alleging rights violations. In the last 4 years or so, we have seen a noted uptick in case submissions from faculty members at institutions, both public and private, who have been targeted for online harassment and calls for termination, sometimes death threats, sometimes quite terrifying, scary, deliberately so, targeting for their speech as private citizens on matters of public concern. This has come in large part, I think, as a response to the kind of social media discussions that come from the president on down. In fact, in 2 of the cases I'll discuss today, it is not hard to draw a clear link from rhetoric from the president on his Twitter account to that which reaches faculty members' inboxes and results in termination, suspension, discipline, investigation, criminal investigation, and worse. I will note, just as a matter of cause, that we have seen faculty targeted for online harassment and calls for termination for private speech that is protected under the First Amendment from both the left and the right, and FIRE is a proudly nonpartisan organization. But given the topic today, the examples I'll discuss involve calls for censorship and censorship from the right. The first example I want to talk about is a professor by the name of Jeff Klinsman, who FIRE represented in a case against his former employer, Kirkwood Community College in Iowa. Mr. Klinsman is a professor of English. He had been there as an adjunct for some years. He was looking forward to retiring in a few years. President Trump tweeted on July 27th, 2019, that consideration is being given to declaring Antifa, the gutless radical left whack jobs who go around hitting only non-fighters, people over the heads with baseball bats, a major organization of terror, along with MS-13 and others, would make it easier for police to do their job. On his private Facebook page, Klinsman commented with a picture of the tweet, "Yeah, I know who I'd clock with a bat." This is a classic example of protected political speech by a private citizen on a matter of public concern. Commenting about something the President of the United States says is certainly commenting on a matter of public concern. It was his private Facebook page. He's not speaking as an employee of Kirkwood Community College. The facts are fairly clear here. Nevertheless, the kind of partisan outrage machine sprung into effect. The local news station, tipped off by somebody that a professor had made this statement, contacted Klinsman, asked him about this statement on his Facebook page and said, "Are you Antifa?" And Klinsman said, "Yes, I affirm that I am Antifa, anti-fascist." For this, Kirkwood Community College, which is a community college, they do not have an abundance of funding to hang out and handle death threats to professors, started receiving complaints. They put Klinsman on leave, and then later gave him a choice that he could resign or he would be terminated for this comment. FIRE represented Klinsman. We made clear, first in a letter, which I've uploaded to my presenter portal, and later in our negotiations with the school, that this would violate his First Amendment rights. The president of Kirkwood, perhaps illustrating the dynamics of social media outrage, media pressure to take action against speech that offends partisans, said, "I will do what I have to do to keep the college safe and deal with the legal consequences later." In other words, willing to throw the professor under the bus to censor his protected speech in order to quell the baying hounds of partisan outrage. I mean, that's a sad commentary, but that is exactly what happened. And happily, once we negotiated with the university, we were able to secure a settlement for Klinsman, averting the need for litigation. But it is stuck in my mind as a cautionary tale. Klinsman wanted to continue teaching, and now he is retired early because he criticized the president, and in so doing brought partisan threats against this institution. And that's the first example. The second one is not necessarily in response so directly to President Trump's tweets, but I think is illustrative of a similar kind of dynamic. Professor at Rutgers, New Brunswick, Jim Livingston, a few years ago, FIRE also defended him. Livingston had commented on his private Facebook page. He's a resident of Harlem. He's a white man. He was critical of young white children at his favorite neighborhood hamburger spot. And he said somewhat glibly and obviously sarcastically, "I'd like to resign from the white race." He's a history professor. He was invoking the teaching of Noel Ignatieff and others who have been critical about the white privilege from a vantage point of a white man. Rutgers filed a claim of racial discrimination against Livingston for his comment on his private Facebook page. Again, kind of spurred into action from local media pressure and a campaign mounted, frankly, from neo-Nazis. In researching the case, we found some of its origins on stormfront.org, which I felt like I need to clean my browser after going to verify that in writing the letter. I've also uploaded that letter here. Rutgers did do the right thing once we engaged with them representing Livingston. But again, just to show how private speech on matters of public concern in this day and age, in this tone, can bring pressure to bear on an institution, serving as a classic example of a heckler's veto. And with that, my time is up, and I thank you all for listening.
Thank you so much to all of you. I hope that those of you who are joining us in the audience have found these remarks as insightful and, thought-provoking as I have. I have not seen any questions in the chat, although, hello, Brad Earhart. It's wonderful to welcome you. If you have a question, please pose it. But in the meantime, I'm going to take a moderator's prerogative, and I want to go back to Ruth because, Ruth, you didn't get a chance to talk about that last kind of example of how insults, impede progress. And that's the kind of deadweight effect on reform. And I want to hear more about that because now that we have President-elect Biden and we can say with assurance that we have a Democratic Congress, we might expect some progressive reform. But this lingering kind of Trumpist sentiment, tell us about how that might impose some deadweight on the attempt to reform that we might see coming from this new administration.
Well, that actually takes me to my latest work that I've just begun that's called The White Supremacist Constitution. And I know that people don't want to hear this, but I think we as academics are well aware of the history of the United States Constitution, that we're a country founded with slavery, that the Constitution protected slavery, and that in some ways, I think the Constitution itself is a deadweight against achieving racial equality as well as equality for many other groups in our society. And, you say, well, that's a pretty broad claim to make, but just to give, this isn't in the workplace, although I can give an obvious workplace example, which is what has the 14th Amendment's Equal Protection Clause come to mean? It's come to mean, and this relates to what was just said by Will, it comes to mean that white people aren't supposed to face race discrimination, right? When we try to even the playing field out a little bit by having any kind of racial preference in employment. And I don't think there's any doubt that if there's anything the Roberts Court is going to do, that it is going to completely dismantle the remnants of affirmative action that we still have permissible under the 14th Amendment Equal Protection Clause. But it's not just going to stop, obviously, with the 14th Amendment litigation, which is only litigation that goes against public institutions like the university that I work at. But it's pretty clear that the courts will then also most likely take that same doctrine and apply it vigorously to Title VII to reach the private workplace as well. And so I mean, what's the solution here? I mean, that's obviously a really hard question, but I think that our Constitution, I mean, the Electoral College, I mean, everything about our Constitution is to empower white supremacy. That's always been what our Constitution has done. And there have been brief moments of Reconstruction, but they've always been brief. And, it is a little ironic today, that it's Republicans who were complaining about the Electoral College. I mean, come on, folks. We understand what the Electoral College typically does. And with the Electoral College acting as the deadweight that it acts on our representation in the United States Senate, we know what that means, right? That means that President Biden has much more limited avenues for what he could seek, even if he wanted to, because he would have to get civil rights reform through a filibuster-proof U.S. Senate. And although I know that happened briefly during Obama's first term, I don't think anyone's projecting we're going to have 60 liberals anytime soon in the United States Senate. So yeah, that's a pretty heavy thing to say. Thank you for asking. But I would say that one of the many dead weights that we have, and tying this to the Public Insult Playbook, I mean, in my book, I go through the awful historical examples of what white people, for example, have been saying about African Americans and Africans since our nation was founded, and those views are reflected in the document that we live under.
Thank you. And again, you're right, not just Congress, but obviously Trump with his 3 appointments to the Supreme Court means that we cannot expect any kind of, sympathetic decisions coming out of that court. And obviously, we got the Bostock decision, but, as Sahar, Professor Aziz pointed out, we have not had, generally speaking, favorable decisions coming from the federal courts on anti-discrimination enforcement at large. So we have finally a question in the chat from Suzanne Goldberg. And this question is really, I think, directed towards several of the panelists who've talked about, Professor Aziz and Professor Iyer, who have talked about the doctrinal implications. And she says there seems to be few courts willing to treat insults as something other than stray remarks, right? This is the reason why overwhelmingly these disparate treatment and harassment cases, get tossed even at the summary judgment stage. And so she says she's wondering if you have any additional thoughts on doctrinal changes that might be helpful, or other regulatory or other strategies that might be responsive to, especially as we've seen the ballooning, right? Professor Green talked about how we've seen Trump's rhetoric really emboldening people to be more aggressive. We've seen even more proliferation of this kind of conduct. Is that going to somehow shift stray remarks doctrine? I guess we can start with Katie and then move over to Michael.
Great question. So I will just say straight out, I think the stray remarks doctrine has no reasonable foundation in the actual text of anti-discrimination law. I think it should be abolished. When I teach this to my students, so for those who may not be familiar with the doctrine, right, the idea is even if somebody in the workplace, even if the very supervisor who has fired you in the workplace has said something truly racist or ableist or anti-LGBTQ, that we are going to say, if it was not, say, said in the context of the decision-making process, or it was said a couple years ago, that this is a stray remark that has to be disregarded, that cannot be considered in the whole facts and circumstances of whether or not discrimination took place. As I tell my students, this is essentially a tool for defense attorneys to try to eliminate the most damaging evidence in many of these cases, right? It is clearly relevant, especially where the comment was made by a decision maker, right? Even if that comment was made 2 years ago, it is clearly at least relevant to the question of whether or not we think discrimination took place. So to me, thinking about doctrines like the stray remarks doctrine and how to address those, I really think cases like Bostock actually give a good signal of what is in this political environment likely to be the most effective approach, which is focusing on the language of the statute. And as a variety of scholars like Sandra Sperino have written about, right, there really is no basis for doctrines like the stray remarks doctrine in, if you look at the language of Title VII, there is no way to derive some special rule of evidence from Title VII that must be applied specifically to anti-discrimination law cases. So I think leaning on the sort of wide disparity from the text of Title VII as a way of dismantling both stray remarks and other technical doctrines of this kind is significant. And just one last quick thing, right? In the only case in which the Supreme Court was faced with this issue in the context of or squarely faced with this issue in the context of a case called Reeves, they rejected the lower court's approach of disregarding remarks under the stray remarks doctrine. So this is really a creature of the lower courts, and I think there are some powerful tools for potentially dismantling it.
So to address, I want to mention something that Professor Coker said, and then also address this question. We have a history from the beginning of slavery until now, and this is not my couching of this. This is something I've actually heard Devin Carbado at UCLA mention, where we have a history of retrenchment after reform. So you make some kind of positive effort to try and reform issues based upon race. Over time, that will be met with retrenchment. So whether it's Reconstruction, going to Jim Crow, it's Brown versus Board of Education, going to anti-affirmative action efforts. And as we continue to think about doctrinally, what are the right reforms, even now we're talking about the Senate, but you probably need 60 to actually pass major legislation reforms. You can certainly get through appointments and things of that nature. Reforms are going to be very difficult to address. So what do we do doctrinally? Certainly, you could suggest things like bullying, and those have been out there before as mechanisms to deal with kind of mistreatment through the use of certain words or whatever. I do think that, and Katie mentioned this, there is hope from the Bostock decision. And one of the things that is hope is how Justice Gorsuch so broadly talks about causation. To me, he opens the door up to a lot more intersectionality claims by basically opening the door where all it may take is a little bit to suggest that race played a role. So you might call it stray remarks, you may call it something else, but that this is just enough for causation, especially under Title VII with its causation standards, where you can at least get through maybe a motion to dismiss or summary judgment process and bring these claims up more in the workplace, because a part of that retrenchment, every time there's reform, there's an intent to cast that reform to focus on purposeful addressment of race issues as if you yourself are discriminating. And one of the key issues with that was the recent attempts to have an executive order banning training based upon racial insensitivity and implicit bias.
So Professor Kolker, I understand you have a disability litigation example you want to offer for the audience. Please jump in.
Yeah, this is just a brief one, but it really picks up on what Katie and Michael were saying about the text. And this is sort of my deadweight argument that you have the text and it still doesn't, it's not enough, right? So just to give a quick disability example, this is from the field of accessibility, of having hotels and motels and restaurants and supermarkets accessible to people, often people with mobility impairments. And a lot of lawyers, or some lawyers, have made a living out of bringing those kinds of cases. It's pretty easy to find places that aren't in compliance with the letter of the law. The regulations could not be more precise. How many inches this way, that way, slope, everything. You don't need much to be able to figure out things aren't in compliance. And so some lawyers bring cases on behalf of people with disabilities. And I actually started thinking about my book almost 2 decades ago when I was at a conference with a friend of mine who was a judge, a very liberal judge. He goes, "Ruth, I know you do this disability stuff. I keep having all these cases brought by these lawyers. They're drive-by litigants," which of course sounds like drive-by shootings, right? They're drive-by litigants. And I'm really troubled by all these cases. And I now have to decide their attorney's fees. And is it fair for them to, make attorney's fees off these cases? And I won't say who it was, but I said to her, well, were these cases successful? Were these places out of compliance? She goes, "Oh yeah, they were out of compliance." I said, so what's the problem? There is none. But that was a situation where the media, and there was a 60-minute episode on drive-by litigants, which is a show in my disability class, which is disgusting. And so there could not be something more clear. Like, all you need is a tape measure. And you could see that these institutions were out of compliance, but yet even liberal judges were feeling uncomfortable because of the way these plaintiffs are being castigated as drive-by litigants. So we can just multiply that by all the examples of all the other fields that everyone on this panel works with to show how hard it is to even get courts to apply the letter of the law.
Thank you for that. And speaking of framing, right, it's all about the narrative and how you construct the narrative around the case. Stephanie Bornstein asked about this assault on facts that we've seen that has emerged under Trump. And so we're talking about stray remarks doctrine, and people can say bad things, but those bad things can be spun, right? You know, so you see people marching with tiki torches, and then you talk about there being good people nevertheless on both sides, right? So what are we to believe even in the face of objective fact? And how is that already affecting cases, for instance, Will, that you're seeing, you know, how people can spin things, you know, a number of different ways, and they're always, you know, strong constituencies, you know, arguing their point on either side. How has that affected how these cases are being litigated?
That's a great question. I'll dive in here quickly. It brings to mind a situation we had at a community college here in New Jersey, Essex Community College, where a professor went on Tucker Carlson's show on Fox News to defend Black Lives Matter protests. And she was, as I recall, suspended and then terminated for doing so. And the president of the institution defended the discipline by saying that he had received an avalanche of complaints. Fire filed an open records request and had to litigate it to get the responsive documents. Turned out it was about 2 phone calls. So again, you know, it's easier for institutions, and I'm speaking of my narrow field here, public institutions, and not workplaces generally, although there's no open records laws for private workplaces. So who knows? That's a real black box there. But it's easier for institutions and sadly so to make the calculation that we will throw our own faculty to the wind to get out of a week of bad PR from the right or the left or on social media. Again, particularly in these cases, speaking of the topic today, from the right. So in other words, better to capitulate to angry emails that weren't even from the state of New Jersey, as I recall. These are folks who had seen this professor on Fox News and, you know, fired off some angry emails. And that was that. And I'm just also reminded of this classic insight from Saul Alinsky, right? A tactic that your people enjoy is a good tactic. Well, it turns out a lot of people like getting very angry and writing angry emails to heads of institutions, you know, or writing death threats. It's ugly. It's disgusting. But these folks, they're going to keep doing it. So what we've tried to push institutions to do is to anticipate beforehand that your faculty members are going to have political statements of their own to make, and that instead of bowing to the outrage mob when it comes for you, have a pre-commitment, a pre-controversy commitment to respecting the expressive rights of your employees, so that it will not be an option when it's politically convenient to roll over to do so. You know, get out there, make a pre-commitment strategy to defending expressive rights. I'll leave it there.
So Professor Aziz, you mentioned having a database of 272 cases and growing. And so particularly in the more recent cases, have you seen courts grapple with this kind of assault on facts and I'm entitled to my own truth, right, kind of play on using evidence?
Well, that's a great question. And I want to first just get to, I just want to address the stray remarks issue because it's related to this. So this is more of a jurisprudential response, but I think that judges are failing to understand the severity of many of these statements. I mean, when you're dealing with the pervasive, right, severe or pervasive, it's more easily objectively calculated or measured. But when you're dealing with the severity standard, that really is a normative cultural question. And the problem is that many of these judges, and I haven't looked as much at the jury bias because many of the cases don't actually get to the jury, but they don't understand just how offensive some of these statements are and the impact on the employee who is already in a vulnerable position, because it's not as if you can go to 3 or 4 or 5 other Muslim employees, if I'm going to use Muslims as an example, and kind of find a tribe or a support system that can say, no, you do belong here. Don't worry, we'll make sure that you are not disparately treated, or this isn't a signal that your job security is on the line. You're on your own, right? Especially when you are a minority of a minority. And so, I mean, we can use all kinds of examples from the noose, right? There was a time when having a noose was, oh, well, that's not a big deal. Of course it's a big deal, but it's a big deal because we understand the context, we understand the history. And so I think that we have a heavy lift, litigators in particular, and plaintiffs' attorneys, but I think the legal professors also have a role to play in educating judges and changing who's on the bench. Now with the jury bias, I realize it's a bigger project. But with regard to your empirical statement, I'm admittedly still analyzing many of the facts, and we don't have as many cases because it takes so long for things to get through the pipeline. A lot of the cases that have been filed under Trump have actually, the underlying events happened under the Obama administration, for example, or under the Bush administration. But we haven't seen any significant changes in terms of how the judges are dealing with the facts. I think, well, I can tell you from my empirical analysis of the cases from 2001 to 2008, which went into the 2009 article, that it's even worse in terms of the ignorance and the lack of knowledge by judges about anti-Muslim stereotyping. What I'm hoping I will find, I know this is a very perverse aspiration, is that the explicit and onslaught of anti-Muslim racism and the Muslim ban under Trump has awakened both the society and the judiciary to realize, oh, this actually is a problem, right? We do have a systemic bias. These aren't stray remarks. This isn't one bizarre person, but this is a broader part of our racial politics. And so I'm still digging through that and waiting for these cases to go through the system. But again, that doesn't change the ultimate doctrinal problem. And I just want to finalize and say, I want to give a shout out to my colleague, Professor Katie Ayer, because a lot of people should know that her article, Statutory Originalism and LGBTQ Rights in the Wake Forest Law Review in 2019 was cited by the Supreme Court in Bostock, and we're all very proud of her influence in that case. So
thank you, Sahar. They didn't actually cite me. People just recognized that they saw the logic of where it came from, but they didn't bother to cite me. But thank you so
Professor's dream, right?
Speaking of Professor Ayer, Kyle Velty has asked the question that, of course, is on everyone's mind, which is that, yes, Bostock was a seeming success story, but of course there was the nod to RFRA, and we know that the court has continued to grapple with trying to reconcile the acknowledgement of LGBTQ rights with their intent on expanding religious freedom in this country, particularly on behalf of Christians. And so what does that mean? Has it really given us some sense to be more reserved in our expectations of LGBTQ rights enforcement?
This is a great question, and if we were in person, I might just ask Kyle to speak on this issue herself, since I know she is actually probably more of an expert than I am on the subject. I'll say just a couple of things. I mean, first, with respect to RFRA, we have a major undecided issue with respect to RFRA and whether it will be a major obstacle in the employment discrimination arena specifically, which is that the courts have not yet held whether a private litigant, a private defendant, in a context where they're sued by a private plaintiff, can raise RFRA as a defense. And if there's a circuit split on that right now, if we get a favorable ruling from that ultimately on the Supreme Court, that would vastly narrow the circumstances in which RFRA will stand as any kind of obstacle. It simply would not apply in the vast majority of employment discrimination cases where the case is brought by a private plaintiff. It would still apply to government cases brought by the EEOC or the DOJ, but it would really, given that the overwhelming majority of cases are private plaintiff cases, or where you anticipated a RFRA defense, it might make sense to bring it as a private plaintiff case, not as the government alone, right? That would really dramatically narrow the scope of that impact, at least for the employment context. We do, of course, however, also have up before the court this term a case that could potentially sort of expand the scope of not just the application of RFRA, but more generally of the protections given by the First Amendment to individuals seeking to discriminate where they allege that their religious convictions played a role in that. That's the Fulton case addressing the actions by the city of Philadelphia terminating the contract with Catholic Social Services to provide foster care because they refused to serve LGBT families. I think the sort of tentative good news, I'm always reluctant to read the tea leaves in oral argument, but I do think there were some signs in Fulton that the court may not be willing to go as far as some people had feared. Remains to be seen what the final language of the opinion will look like. But under current doctrine, if a law is a neutral law of general concern and it's applied equitably, there should not be a defense there to anti-discrimination enforcement. That's the Smith decision, and there didn't appear to be an appetite on the court for overturning Smith. So remains to be seen, and again, go read folks like Kyle's articles to know much more.
Thank you, Professor Iyer. I'm going to combine the last two questions in the queue. Both Zenata Joyner and Deborah Wittes ask about some more hopeful notes. Zenata asks about what we can do to effectuate real change, not just sympathy, not just reaction, right? Not just kind of hashtag activism, but some real change. And Deborah asks about whether or not the last couple of days give us any more hope that because we are all so collectively outraged, I mean, obviously even Republicans, Mike Pence, Mitch McConnell, longstanding supporters have repudiated, the most recent actions. And so because we know that Trump's administration has signaled a very divisive, inflammatory, and oppositional stance to any kind of civil rights or anti-discrimination enforcement. But we've seen kind of a public reaction increasingly to reject that. And I want to hear everyone in their closing remarks comment on whether or not you think, in the same way, for instance, Georgia voters repudiated both Loeffler, right, and Perdue. In response, we might see an opportunity in this moment for there to be even greater enforcement, if not in the kind of public context, at least in the private context. So just like we saw, private industry repudiate Trump's rejection of the Paris Climate Accord, and we saw, private industry repudiate Trump's opposition to the Black Lives Matter movement by embracing it. Can we expect that there might be some larger public embracing of more robust anti-discrimination enforcement, given the kind of overly negative and even violent sentiment that's been expressed over the last couple of days? I want each of our panelists, back in the original order, to take a moment to give us some closing hopeful remarks.
I guess I get to go first to be hopeful. My colleague Amna Akbar, who I'm sure a lot of you are aware of, has written some really powerful pieces. She has a piece that just came out on the Harvard Law Review Forum, and she talks about the need for what she calls non-reform reforms. And I don't have time. I use up all the time to talk about her important work, but I think that the message that the lesson we should be learning is that it's at the local level. We're going to have change. We can't expect the courts to be our salvation. We never could, but we especially shouldn't in these times. But that at the local government level, we can be talking about structural changes, and we can talk about it in the private sector with respect to industry. And that if we succeed in that way, if the Black Lives Matter movement continues to be the multi-generational, interracial movement that it is, and we can succeed at that kind of local government level, maybe we'll have reforms that are more long-lasting, more structural, more meaningful, instead of the cumbersome nature of one litigant at a time, which we all know takes forever and isn't an effective way to achieve structural reform. So I guess that would be my point of optimism.
So I hate to be pessimistic. I don't have optimism, and I'll tell you why. Even what happened with the last couple of days. If you look at voting, you say we took Georgia or whatever, whoever side you're on, it's still very divided. It was very close. And if you look at how many people voted for President Trump, despite all the things that we have highlighted, the country is very divided. And what happened with George Floyd, I'm writing an article right now that's looking at police discipline and arbitration and what has happened. And one of the things that you see is that there was supposed to be transformative what happened with George Floyd. There were many people who were out there protesting, white and black, all different colors. And if you apply kind of something that Derek Bell has said about interest convergence, that is kind of the hopefulness. Now you're seeing companies, now you're seeing all races, all these people saying it's wrong. Yet you see almost close to half the other country not thinking it's wrong. Until we have, and we saw what we saw yesterday, we saw so many Republicans still vote to challenge the electoral process, which shows that there is still such divisions in this country. The last thing I'll end on, and I want to go back to John McCain. When John McCain was running for president, and he was having a rally, just like President Trump has these rallies, a woman came up to him, and this goes to what Professor Aziz is also talking about too. A woman came up to him and says, "I can't vote for Obama, he's an Arab." And John McCain said, "No, stop, no, he's a good man. He takes care of his family. We just disagree." When we get to that point in our society, then I'll be hopeful. When you see more people who are on the other side is not making it just partisan, but are actually trying to work together, then I'll be hopeful. There's some good things out there, but movements have to really be the mechanism to do it. And I hope that we get that support.
Okay, well, here's some I don't think these are pie in the sky recommendations, but one, we need to increase funding to the EOC. We've been starving that organization intentionally and purposefully for many decades under Democratic and Republican administrations. Now, I'm not saying that the EOC is a panacea, and it certainly won't necessarily change the doctrine, the doctrinal problems, but I think that at the very least, it will bolster deterrence, because when you have more investigators and more lawyers, employers are going to know that they're more likely to get caught, right? If they don't ensure that the anti-discrimination laws are enforced in their workplaces. Second, I think, well, this isn't optimistic, but it's gonna get worse before it gets better, because we just witnessed 50+ federal judges be rammed through confirmation by McConnell and the Republicans. And that effect is still to come, and essentially our students are going to deal with the ramifications for their entire careers. So that makes litigation even less likely to be the forum from which we can see some more systematic, broader reform. I think the upside is that we are very influential people as legal academics, because we're training the next generation of lawyers. We're training the next generation of political leaders. And that is a very influential role. It's a very long satisfaction. What's the right word? I'm blanking on names. Delayed satisfaction, right? There's delayed satisfaction to see the results, but it's still important. So I just want to point out that we need to continue, or we need to do more, I don't think we do enough, of training our law students to be advocates, not just litigators, right? They have got to be able to tie in community organizing, public policy advocacy, and litigation. And that's not easy to teach, and it's not easy to do, but that's what we need more of coming out of law school in order to connect the law and society component for reform efforts. And then finally, I think that this is a positive development, and we just need to continue to pay attention to it, is the strengthening of watchdogs, right? Legal advocacy watchdogs and civil society. So as somebody who studies the Middle East and in countries where there's very weak civil societies, I have a deep appreciation for the important role of these whether it's the ACLU or the Center for Constitutional Rights, or there's multiple organizations, but I do think that we shouldn't underestimate
Thank you so much, Professor Aziz. Again, I'm sorry to interrupt. I just want to give our last two speakers their minute to conclude. Thank you.
So just very briefly, I will say the thing that I found most hopeful and optimistic over the last couple of days is the the effects that we've seen of effective community organizing and movement building in reaching the result that was reached in Georgia, which I think many sort of traditional political elites would not have thought possible. And I agree with all of the panelists who've spoken that that is the future of effective reform, right? It is not simply legal reform. It's not bringing individual cases. It is building a movement for sort of common regard, respect, equality for all of the groups that make up our society. So with that, I'll leave it to Will to.
Thanks, Professor. I'll be likewise very brief. As a First Amendment attorney, I couldn't do this job without a fundamental optimism. It would be too tough to wake up every day. I will put it like this. I think the last stretch of our political and civic life has been exhausting and miserable for almost all involved. I believe that anger is a powerful fuel, but at some point it will burn out. And I think that to echo some of the good comments, I think from Professor Aziz, the education that this experience of the last 4 or 5 years will provide for students, whether they are in kindergarten, like my son in the next room, or a law student, might be instructive. That is, they will define themselves by remembering this exhausting, miserable, untenable stretch and say, let's do something different. So as a First Amendment attorney, again, echoing Professor Green, if we can find a space to discuss without demonizing, we'll be the better for it. So here's my hope.
Thank you for ending us on that hopeful note, Mr. Creeley, and thank you all for joining us for this program. I hope that you enjoyed this discussion as much as I did. I hope many of you will be able to join us for the section's business meeting immediately following this session. I've put again in the chat the Zoom link for that meeting. Thank you all and enjoy the rest of the conference, and we hope to see you in person next year.
Bye.